So to begin, just out of interest, what prompted you to write a book, and more specifically, this book, especially by your background of being a recognized, respected public international and international human rights lawyer, to suddenly transition and write your own book?
Yes, before I became a lawyer, I was planning to be a writer, but it's incredibly hard, if not impossible, these days to be a writer as a primary career. But I always wrote fiction. I didn't expect to write a non-fiction book. But when I first heard about Cambridge Analytica in early 2017, was when I first started thinking about the right to freedom of thought in relation to technology. And when I started looking into it, I found very little out there, whether in academia, in case law, in commentary. It was all focused on privacy, but my feeling was very much that freedom of thought was the heart of the problem and something that would resonate with the wider public, because it was something that really shocked me, this idea that my mind could be being accessed and manipulated for political gain, if you like. And the more I looked into it, the more I realized that it was really core to a lot of the developments in technology that are highlighted, for example, in Shoshana Zuboff's book, The Age of Surveillance Capitalism. So I started work on freedom of thought. The thing that tipped it over into thinking maybe I should write a book was reading Yuval Noah Harari's Homo Deus, which he talks about how humans are becoming hackable, if you like. He talks about the hackable human and the sort of deterministic tech future. And his book was firstly very persuasive, but secondly made me deeply disturbed and quite angry about the take on human rights law. So it made me want to write a similar public-facing book highlighting why human rights matter and why they could be the answer for our human future. So it was two things. It was one, I think, reading about Cambridge Analytica and finding that something so disturbing. And then secondly, reading a very popular book about our future and feeling like that book needed an answer, or those arguments needed an answer that would be accessible to the public. And so I decided to try and write a public-facing book about this idea of freedom of thought and why it matters and why we need to think about it now.
Transitioning to specific themes and discussion points of your book, specifically beginning with AI bias and profiling. There's a great danger to AI being trained with emotional analysis and face reading, as we give machines the platform to make assumptions about extremely personal issues, especially as you pointed out, personal issues like social and political orientation. And the first part of your book provides the historical grounding of the right to freedom of thought, and discussing how it was previously violated through the Salem witch trials, religious persecutions, science experiments on the brain, and the Nazi propaganda. So what, in your opinion, makes the AI invasion that we are currently facing today more dangerous and concerning than what was historically done?
It's not necessarily more dangerous or concerning than what happened in history. I suppose the first half of my book, I was looking primarily at what was happening before the Universal Declaration on Human Rights. So before we had international human rights law to constrain it, if you like. So I suppose what I find concerning now, particularly in the context of AI, is the narrative that we don't have a legal framework. So you'll see them vaguely talking about ethics or saying, well, we need global regulation. Actually, we have a global legal framework that identifies human rights that our governments have an obligation to respect, but also to protect, which means that our governments have obligations to protect us from potential human rights abuses carried out by companies, carried out by each other. And so I think what's disturbing now is that, particularly in relation to the right to freedom of thought and inferences being made about our inner lives, we are somehow being conned into believing that there is no legal framework and that it's all terribly difficult to manage. Whereas really what I think we're looking at is a crisis of effective application of human rights law, rather than an absence of law or a regulatory vacuum.
I think that's definitely a point that I want to cover later on about the effective application of human rights law. I'd be quite interested in your points on that. But just a bit more on this topic. Again, going a bit more about the issues that we've previously faced with breaches of human rights, is that massive human rights atrocities have always been based on judgments such as racism, xenophobia, classism, misogyny, homophobia, and prejudice against people with disabilities. And so the idea and why everyone's so excited with AI is that it's also designed to analyze the data provided with it objectively and with reason, and sort of detaches the emotion that people have. So, and essentially, AI is arguably as good as you make it. So it should function objectively based on the information that you provided with. So if we gave the AI the correct data and we as individuals detach the issues and the bias that come with it, is there not capacity to argue that AI bias could actually be the lesser of two evils between human bias and the AI simply just taking the data given it and doing what it's said to be done?
I think it's not necessarily an either or question. I think one of the big problems with, I mean, it applies to both to a degree, but is how you explain the decisions that the AI is making, as well as the kind of the automation bias. So our inclination to believe what a computer tells us. And so one of the examples that I talked about in the book was with sort of credit risk assessments in financial services industries. And when I was working as an ombudsman, I had a case where a woman's credit level had been dropped without warning. So one of the problems was the lack of warning, but the really interesting thing was that when we went back and said, well, why did you drop her credit level? They said, oh, well, the computer said no, effectively. So it was, it was an algorithmic process that decided that her creditworthiness had dropped. But when we went and said, okay, so can you explain what it is about her that means that her creditworthiness has dropped, they couldn't answer. And we went back and forth. They had no good reason. And they said, oh, it's probably in her credit record. So I provided the credit record and said, well, have a look at the credit record. Can you see anything on the credit record that you can point to that might have triggered this change? And of course they couldn't. So, in the ombudsman environment, what you have to decide is whether a person's been treated in a way that is fair and reasonable. Clearly, it can't be fair and reasonable if you can't explain why it is the case that this has happened to someone. If it's totally inexplicable, you can't know that it's fair and reasonable. So I think that is one of the issues with algorithmic processing, is that it's very difficult to know what the fly in the ointment might be, if you like, or what the ghost in the machine is that is triggering apparently biased outcomes. I mean, you could say the same of human beings, but it's in some ways potentially easier to challenge a human being if they can't explain their decisions. It goes with issuing judgments. You have to explain why you've reached the judgment you have. And the same, going back to the ombudsman example, you have to be able to explain rationally why you've come to the conclusion about what's fair and reasonable. I mean, one person may come to a different conclusion to another, but they need to at least be able to explain what it is and why they're reaching those conclusions. And I mean, it's also the case that, using automation in certain circumstances could be useful and could provide a better level playing field. The question is, in what circumstances is that going to be the case, and how can you check? How do you make sure that what's going in is unbiased? How do you make sure that there aren't unintended consequences of the system? And what do you do when it goes wrong?
Drawing on your last point, where actually in some circumstances it could be used and it could be beneficial, what circumstances do you envision that to be? Do you see that in the sense of perhaps job applications that AI profiling could be used for good? Because, for instance, in the US, in college admissions, there's this process of affirmative action to really promote minorities from certain backgrounds to have the same opportunities as other individuals. And also, I know in the legal industry, there's a lot of discussion of promoting women and people from certain minority groups as well to get access, and potentially having AI sort of to draw these individuals from a certain background so that they're not overlooked from the typical white Oxford candidate. Do you think that could be a good use case, or do you think that just continues to, I suppose, marginalize them?
As far as I've seen, that doesn't work at all. Why it doesn't work, is debatable, but I haven't really seen any examples, any shining examples of that functioning in practice. Rather, I've seen an automation of the opposite. So, companies where they created an algorithm to sift CVs for senior management, the algorithm, understands that basically anything with the word women in it is a proxy for not being senior management material. So you take out the identification of whether it's a man or a woman, but if you've been on the women's hockey team instead of the men's hockey team, the algorithm is going to pick that up as being a sign of, well, there's nobody else on the women's hockey team in senior management, so really not the right fit. So it becomes more of an automation of existing biases, even when you try to make it not be, if you like. And I mean, there are other ways of addressing those issues, both questions around affirmative action, but also blind CVs. So, for example, recruitment practices where the people looking at the CVs, you don't include what university somebody went to. You don't include what school they went to. You don't include their name. So you can't make an inference about what kind of a person they are. So I think there are very different ways. And I suppose, arguably the AI could be done to remove those details, but frankly, you don't need to do that. You just need to ask people to submit blind CVs and take the cost of the AI out of the middle.
I suppose the only thing with a blind CV is that sometimes you don't necessarily want it to be blind because you do want to promote the access to it. So as opposed to kind of give them that extra push because you're understanding that they didn't necessarily have the same opportunities initially. So for instance, go to private schools to then eventually have had that job experience that someone with another blind CV would have had.
Two things. So one is the blind CV, where about those opportunities, the fact that you don't know that somebody, what school they went to, what university, I think helps with that. And I mean, there are also ways of promoting diversity, which is not then about the filtering of CVs. So, for example, priority for accessibility for disabled applicants and that sort of thing. And also, diversity questionnaires. So, you can do that separate from the CV passing, if you like.
Next topic I wanted to speak to you about was access to information.
Yeah.
So you make a very crucial point to freedom of thought, that it also aligns with having access to information, because individuals should be able to form their own opinions based on content and information online that they can rely on. So my question to you is, who makes this call? Because I actually had interesting conversations in the past before I was even read your book about this. And a prime example, for instance, is in the context of the US. I think it's quite evident that our political opinions would align with Democrats, and we would be quite adamant to have strict gun control, or in my mind, no gun law for the public. But you could argue that this, and we would argue that it's actually misinformation that conservatives are spreading, the argument that this ensures safety and upholds liberty despite the mass shootings occurring. But equally, spreading the news about how the right to bear arms is an outdated constitutional right and is promoting shootings based on stigma and deterrent security could also be said to pollute conservatives with our political ideals. So how do we justify this? What gives us this right? Like, how can we say those things, but then not label it as misinformation from their perspective?
There are issues around the way misinformation and disinformation arguments are framed. We have an information economy crisis, but when you start trying to do content moderation, as you're saying, particularly around sort of misinformation, where you're on the kind of the gray areas, you can then see very clearly authoritarian regimes, closing down information sources on those same grounds. So you can see how that operates. But we do have a crisis of information at the moment. And I think the key issue that we have is about content delivery and targeting. So, the internet is a great tool for democratizing information in theory. So in theory, you can access information that, for somebody like me growing up in a small village in the area before the internet, theoretically, we didn't have access to, except through libraries. And that's why, libraries are a key thing for freedom of information. But what has happened is that the way that the internet works today is that it's very much targeted. So it's not about you going and seeking information freely in this wonderful new era of accessibility. It's about the way the information is being targeted and fed to you as an individual. So I think that is the issue. Rather than the content, it's about the targeting and the profiling. And the example that I used in the book, which I found fascinating, was the Flat Earth Society and YouTube, and how researchers in the US went to a Flat Earth Society conference to find out how people came to believe the Earth is flat in the 21st century. And literally everyone bar one of the people that they spoke to had come to the conclusion that the Earth was flat through YouTube. So they'd gone on YouTube looking at other conspiracy theories. They hadn't gone on YouTube to search about the flat Earth. They'd gone for something else. And YouTube recommender algorithms had sort of said, okay, you're someone who's interested in conspiracy theories. Have you ever thought about this one? Maybe you'd like to hear about the Earth being flat and the moon landings being a hoax. And they were then fed a constant stream of this information in a way that becomes, if you like, brainwashing, personalized brainwashing. The only person who didn't get there through YouTube had got there because his son and daughter-in-law had got there through YouTube and persuaded him that this was a great idea. So I think that is the issue, is it's not what the content is, it's how it's being fed to us, which I think is the big issue on freedom of information. So we have the impression that we've got access to all of this amazing information, but actually the way it's being delivered is very targeted and personalized and designed to exploit our personal vulnerabilities.
And that's quite interesting, because that speaks a lot about the source of the information. And I think that becomes even more of a prevalent question with ChatGPT, because you feed in a question and you get the answer, but you have no idea where that information was extracted from, where they got the information, and what, which bias was implemented in it from a specific source.
So from my experience, the answer is complete rubbish. It's just made up.
Don't even get me started on the hard
Yeah.
law firm. Oh, that's quite problematic. But how do you see regulatory frameworks coming in place to protect users from this? Or maybe let me rephrase it. What would you like to see happening to address these issues?
Regulation that works sort of from the inside out. So regulation about what you can use tech for, I think, is important, rather than, things like content regulation or things that are just nibbling around the edges. So that's one of the things from the perspective of the right to freedom of thought and the right to freedom in our inner lives. is that actually, if you look at technology and often the reasons and the services that are being described by the companies themselves. So look at Cambridge Analytica. They were offering a service which was to understand voters on a granular level, what kind of personality they had, and use that information to manipulate them so that they would behave in different ways. That is literally the service that they were selling. So when you think about the right to freedom of thought as being about the right to keep your thoughts and your inner life private, the right not to have your inner thoughts manipulated, and the right not to be penalized for your thoughts alone. And when you think about that as an absolute right, well, it's clear that what Cambridge Analytica were offering should be unlawful. And so you then don't need to worry about whether or not it was snake oil, whether or not they managed to do it, how many people they potentially manipulated, where the money came from. All that becomes irrelevant because the service itself is illegal in the same way that subliminal advertising was made illegal. So I think it's about identifying certain things like emotion recognition. Emotion recognition tech is designed to understand what's going on inside somebody. And so in my view, that raises really serious questions about it being a violation of our right to freedom of thought. So if you decide that this kind of technology designed to understand what's going on inside someone, so not what they're doing or what they're saying, but what they're thinking and feeling, then you have to outlaw it, if you like. So it's about looking at what is it designed to do. If it's designed to interfere with your right to freedom of thought, then you can't do it. Rather than looking at, well, how did they protect the data? It's like, actually, what's the purpose? So I think purpose-driven regulation is what we should be thinking about for the next wave of regulation.
And further on that, going sort of a step below ChatGPT, just your everyday usage of the web and going on websites and articles. Every time a user, well, not necessarily every single time, but often you're prompted with, do you accept cookies? If so, press agree, and then you can proceed to the website. So I suppose in that sense, the user is consenting to that access in return for information. So sort of that trade-off that you have to do if you want to get access to certain information from that website or that certain article. I suppose my question is how do we address that? Because every time they're accepting the cookies and they're just giving more capacity to trace their usage and their interest, and then that's more when we got targeting news articles to people.
Big question about what you can and cannot consent to. And so while you may, consent to your doctor's surgery using your data for your medical benefit, even if you hit consent, even if you say I consent, realistically, professionally, your doctor should be prevented from sharing your medical data with the local pizza shop to tell them that you're feeling depressed and maybe now would be a good time to target you with advertising for comfort food. That is just something that professionally, ethically, legally would not be allowed. And so I think there's a big question about simply, you can't just sell your soul for access to the surgery or sell your soul for access to Twitter, whatever it is. So I think there are questions about, what activities are legal regardless of whether or not you consent.
Another point that I thought was very interesting was, of course, your discussion on hate speech and specifically the usage of propaganda as a tool. And it's very essential to be able to differentiate between hate speech and what people often claim is the freedom of speech, as you pointed out. And again, this kind of comes back to my earlier question of who makes that call, and how do we ensure this reflects the principles of human rights? And I think particularly what makes me think of this is I think it's quite easy to call out hate speech for people targeting certain ethnic groups, but I think sometimes it's a bit more blurred, more difficult to call people out, especially today. What we've been seeing is, there's mass media and international lawyers crying out on the accountability of Russia and the war crimes, and they can make that distinction. But then you also see by default that the everyday reader is then also beginning to antagonize Russia in general, and not just the government and those that should be held accountable, but everyday citizens. How do we control this? Because in a way, that's not misinformation, but I suppose it's how it's being construed by the everyday user.
It's complicated because I think there are two things. One is about freedom of expression generally and the kind of content. In places like the US, the concept of freedom of expression is very different to what it is in Europe. I'm probably more European than I am Anglo-American in my approach to freedom of expression, in that I recognize very much the sort of the responsibilities that are inherent in the right to freedom of expression in international human rights law, and the limitations that are put on it. So, free speech absolutism, I think, is a very American thing, but it's also becoming an agenda, if you like, globally because of tech solutionism and the role of America in global technology, if you like. So I think one question is around content, but in terms of who makes the call, the European Court of Human Rights has made a lot of calls about what speech is protected and what isn't, because it amounts to hate speech. So it's going to be on a case-by-case basis rather than there being a blanket question. So I think that's important to bear in mind, that it is a case-by-case basis. Some cases are going to be absolutely glaringly obvious. Other ones will be very context specific. And a line that you say as part of a poem that isn't in a more global context a call for hatred, but that is rather an example of propaganda, if you like, or an example of a call for hatred, is very different to somebody standing on a platform calling people to go and kill other people. So it's very much context specific. But on the other side, I think the big issue that we have today is, again, going back to that kind of question of how information is delivered. So if you look at something like online misogyny, somebody like Andrew Tate, a lot of what Andrew Tate says probably very clearly falls the wrong side of the line, if he were to bother trying to defend his right to freedom of expression. But online misogyny, a lot of the issue with it is not individual comments. Again, it's the kind of the way that the information and the messages build up. So it's more about kind of a gradual brainwashing, if you like, rather than looking at one piece of content and saying, oh, that's definitely hate speech against women. It's about the way an individual is targeted, is groomed, if you like, towards misogyny because of the way online information works. So it's about a kind of a barrage of negative coverage of women, each single piece of content potentially not arising to what might be considered hate speech. So I think that is what's very different in the online environment. It's not so much about content, it's about the delivery methods.
Moving on specifically to discussing the legal framework in this context. One of an interesting quote in your books was, the thing about philosophers is that you can't generally ignore them with impunity. Then you go on to say, but the law is different, and ignoring them has consequences. I love that. And I completely agree with that. However, especially in the context of international human rights law, this of course, you've got legal frameworks, but then a big question is always having that enforcement. But then even domestically, that's an issue. So we live in a digital age where politicians are actually using AI in their favor. I mean, you spoke a lot about your book, how they're using it to manipulate elections and ultimately undermining democracy. But then at the same time, these are the people that we are trusting to make the necessary changes and to adapt to these new innovations to protect us. So what can we do, or I suppose what can the lawyers and judges do in such circumstances to ensure that human rights are protected in this context?
I mean, I think in a way that's several questions. I mean, one thing on politicians, one thing we can all do is vote, to hold them to account, and to keep ask them questions, hold them to account, embarrass them basically into respecting human rights. One of the reasons I wanted to write the book as well was, as I said, really to give a kind of public understanding of why we should all be bothered about human rights, why it's not an issue about somebody on somewhere else in the world. It's something for all of us. What can lawyers do? I think lawyers can consider big picture, consider consider those wider underlying frameworks when talking about the law, when arguing as to what the law should be, is sort of going back to those first principles. So when you're looking at things like data protection, think not just about the detail of the GDPR compliance, but think about, well, why does this matter? Where is it coming from? And how might that expand the way you look at it? So I did some work for the Digital Freedom Fund looking at potential areas of strategic litigation using the right to freedom of thought and the right to mental integrity, which are both in the EU Charter of Fundamental Rights and Freedoms. And so one area I looked at was the sharing of data related to mental health, for example. And so looking at it not just from a privacy and data protection perspective, but also from this perspective that when you're looking at the GDPR, you have to read it through the lens of the European Charter. And so then applying the full range of rights of the EU Charter to try to understand what the GDPR means in practice, including this right to mental integrity and right to freedom of thought. And thinking about the right to freedom of thought as an absolute right and how that then changes the way you analyze the law, how it should work and what the outcomes should be. So I suppose what I would say is take a broader focus in your interpretation of legal provisions with that idea of what does this mean from a human rights perspective behind, and going beyond privacy. And also taking risks, making arguments that potentially open up new avenues.
On that point about having that broader approach, then going back to international specifically, then do you think that we have the necessary frameworks and treaties in place that reflect the digital age with the freedom of thought, or do you think potentially new treaties to be established among state parties to also really get into the specifics of technology and the issues that are coming into it that weren't necessarily foreseen years ago when the drafting initially took place?
Two things. One, I think, is absolutely about access to justice and enforcing the legal frameworks that we have, which is a really big problem at the moment. I think the international rules-based system is very shaky right now. And again, I think that's one of the reasons I wanted to write this book, was to remind people of why it matters and why we should care about it and why we really don't want to lose it. Even though, it may be shifting at the moment, we need to kind of go back to basics and remember why it mattered and why it continues to matter. So I think shoring up the existing frameworks, things like the European Court of Human Rights, has been an incredible tool for developing what human rights mean, and through the living instrument doctrine. But with Russia pulling out, and the UK has been going on for 20 years about how they're going to walk out, I think that would be a very dangerous thing to do, because I think the European Court of Human Rights is incredibly important as a backstop of accountability that protects us from the changing vagaries of politics, to remind us of those fundamental points. In terms of, do we need something new for technology? I think on a domestic level, particularly, we do have a need for effective law and regulation that protects human rights. So putting in place laws and regulatory frameworks that allow us to enforce the basic human rights that we have in the context of technology and AI, I think is really important. In terms of an international treaty, I think unless you have the proper enforcement mechanisms sorted out on the treaties that we already have, I'm not sure how much value there is in a new treaty. On freedom of thought, what I would say is I think it would be really useful to have a new general comment, for example, from the Human Rights Committee about what freedom of thought means in the digital age. So clarifying what it means, I think, is really important, and looking at the development of case law. So starting to see case law at the international level. But otherwise, I mean, we have, there are tons of ethical frameworks, regulation around AI and technology in general is booming, whether it's in the OECD or UNESCO or Council of Europe or other bits of the UN. I'm not sure how useful it will be in the end if we don't have proper enforcement mechanisms. And that's about putting money into enforcement mechanisms. And it's about resisting the temptation for political interference to undermine them.
Actually, continuing from your last point then on enforcement. So that was a very helpful discussion of the framework in international law. But I also thought it was quite interesting in your book how optimistic you were about the international mechanisms that we have in place to help prevent atrocities in the future, and therefore we need to make that ensure that the international justice system is strong enough to bring perpetrators to justice, no matter where they are in the world. And comparatively, I've spoken to other international criminal lawyers who stopped practicing at the ICC because of the process and the low funding and the lack of accountability, and just the issues with each other amongst councils. But you seem more optimistic and hopeful that it could be the avenue to address a lot of these human rights concerns still.
To be clear, we are at a really low point right now. So, I'm not Pollyanna about it, but I sort of believe that rather than ditching those ideas, what we need to do is try to persuade governments and the public that we need to reinforce those things. So a lot of the problem with those international mechanisms, and it's the same with domestic human rights oversight, is lack of funding and political interference. So I suppose I'm not, like I said, I'm absolutely not Pollyanna about the international frameworks. But I think rather than saying, well, what we need is a new one, or just giving up on what exists, what we need is more focus on how to reinforce the international rules-based order. What do we need to make it work, rather than shall we have a new shiny one and have something new that we can ignore? So it is a really tough time to be working in international human rights law or international criminal law. No question about that. But we can't just give up. So you have to keep going and feel like this too will change. But having said that, I don't practice in the ICC and I wouldn't seek to right now.
And so less so about the ICC, and then going back to the European Court of Human Rights, as they are fundamental to ensure that these rights are upheld in Europe. And since human rights law is the key to challenging the status quo, no matter how entrenched it is, allowing us to protect the rights of each other and everyone of us, regardless of how unpopular we may be. Can we always trust that the European Court of Human Rights will be as progressive as we are? So you and me having this conversation, can we trust that they would also agree with the dangers of AI and the invasion it has to the freedom of thought?
No, we can't, but I think you have to believe in progress. And I think one of the key things to bear in mind, particularly when you're kind of working in areas like strategic litigation or development of legal policy, is that it can be a very slow incremental process and there will be setbacks on the way, but you have to kind of believe in the direction of travel. And as to whether or not they will be progressive, I mean, it'll depend who's appointed. I mean, that's the case in any court, really. But it is about protecting the independence of judges, whether they're international or domestic, and looking again at things like funding and protecting against political interference, I think is absolutely key.
Now, a follow-up question I thought was very interesting to talk about briefly was your discussion about the lie detector test in your book. And this is also like inadmissible in many courts.
Yeah.
But I think it's also quite interesting to touch upon because a few weeks ago, I actually spoke to Mohammed Islahi, who is a former Guantanamo prisoner, and he spoke to me about the incredibly degrading torture that he endured whilst he was there. But he also spoke about how he was forced to take the lie detector 3 times, and he passed 3 times. And it's quite interesting because he told me after he had taken that and passed it, one of the prison guards that he had actually had a good relationship with said to him, "Now that you've passed it, you're never getting out of here." Because at that point, they knew they got someone that was more of a witness than a perpetrator of the crimes that he was alleged of, and he would only just expose everything that he endured. But I suppose in that circumstance, it kind of shows how he wasn't what they perceived him to be, and I suppose it did evoke his innocence in a way. Useful because, of course, the torture should never be used, and that's an absolute human right. But realistically, that's just not respected. So if we had something like the lie detecting test, would that not deter torture, more of the physical kind?
Would at all. And also, I think that actually putting someone through a lie detector test itself, particularly in those kind of circumstances, is itself inhuman and degrading treatment. But you know, the idea of, well, is it better to interfere with freedom of thought than to commit torture? You know, one of the things that I find very interesting and telling is that in international human rights law, the protection of the right to freedom of thought in the forum internum is protected absolutely. So it's protected in the same way as torture, as the prohibition on torture and the prohibition on slavery, which shows how really vital it is to what it means to be human. And I mean, there are, you know, a lot of the arguments about lie detector tests go to the question of whether or not they're reliable. Personally, I think that misses the point. And that's, again, where we get, you know, I've heard those arguments as well about torture is, oh, well, you know, the main reason not to use torture is because the information extracted is not reliable. That's what you'll hear from, you know, some people around the world when you go talking about prohibition on torture, particularly in the counterterrorism context. Taking away the reliability question, there is just this question about why it's a violation of a fundamental right and why it's kind of irreversible. And as I say, I think, you know, well, the reasons for torture seem quite obvious, or the reasons why torture is an absolute right seem quite obvious. But with the right to freedom of thought as well, and the lie detector test. I mean, the fact that you're being forced to go through it in order to, get out of jail free or whatever, there's no actual way you can consent to that. There's no way that you can deal with what the outcome of that will be. And so regardless of whether it gets you right, whether it correctly identifies that you're lying or not, it is, I think, an absolute interference with this inviolability of our inner selves. And I don't think it does protect you from torture. I think the two go together. I mean, torture was used as a method of extracting your thoughts. Lie detectors may not amount to torture, but as I say, I think they probably are in human integrating treatment, particularly in that kind of a context. So I don't think it's any better, really. And again, like with torture, you can't justify an interference with your right to freedom of thought. So you can't say we're going to do it because we'll protect people from terrorism by interfering with freedom of thought, in the same way that you can't say we're going to torture someone because of the ticking bomb scenario. So I think the two kind of go together. So no, in summary.
I agree. Another question I want to ask, which I find quite concerning, is the development of predictive analytics, but particularly in the use of law. From at least at work at my end, there's been a lot of discussion about predictive analytics being used as judgment. So again, going into what we discussed at the start of the interview, that potentially AI could be more objective and it could use the data that it already has to come up with more rational decisions that judges that may have more bias and prejudice attached to the subjects wouldn't necessarily conclude as they should. And so the idea is that if you feed the AI with, case law precedents and all the facts, it should be able to come up with a conclusion that follows the previous precedent on a rational basis. And for obvious reasons, this is problematic for us, as how we just discussed. I suppose my question would be interesting to know is, do you think this is just everyone getting a bit too excited about AI? Or do you think at the pace that we are going at now, there isn't enough concern about AI, and actually people would welcome this if this were to really get to the level where it could be tested and used?
I think it is about people getting too overexcited about AI. And I mean, I think in the context of it writing judgments or legally enforceable decisions, there are several problems. One, at the moment, it's rubbish. Certainly stuff like ChatGPT. There was a story earlier this year of a Colombian judge who said he'd written part of his judgment using ChatGPT. But certainly from my experience of using ChatGPT, it just makes stuff up. I mean, it's not real. It writes plausible prose, but that if you are actually a knowledge expert, you know that what it's written is completely wrong. So it sounds convincing, sounds rational, but it's wrong. So I think that is one big problem. I think it could be useful, AI could be useful in things like drafting contracts where there are large parts of the contracts which are kind of pro forma or whatever, and for picking up contractual clauses that may no longer be lawful, or that, that kind of thing. So for sort of bulk work, potentially yes, as long as, again, it's sort of being checked. But for judgments as well, what that presumes is that there is only one answer to a legal question, which frankly, most questions, by the time they get to court, it's because the answer is not very obvious and clear. The majority of cases settle or don't even become disputes because the law is clear. By the time you're in front of a judge, it's because the combination of facts and law means that the situation is probably not very clear. Otherwise, it's a complete waste of everybody's money to be paying the lawyers to argue the points in front of the judge. So I think the idea that AI can solve this by getting rid of bias just to me seems a fundamental misunderstanding of justice and the nuances of law, and the fact that law evolves, and the fact that law is about human interactions. You know, having said that, as I say, there are areas of law where AI could be very useful for dealing with bulk tasks where things are clear, as long as there's somebody checking that it hasn't just made it all up.
Yeah, I've got a few Harvey stories on that point.
Yeah.
Just conscious of time, I wanted to just ask you one more question. Based on everything that we've discussed, how would you say we can, because I think also fundamental in your book is, and it was often you kept honing in on this, is that why it's so important that we recognize the freedom of thought and we understand the human rights, because once we lose it, we may never be able to get it back. And that stuck with me. And I suppose in today's context, how do we ensure we protect the human rights to freedom of thought and do not allow today's digital norm to become permanent? Because I think a lot of these issues that we've been discussing have been overlooked. And especially considering this in the context of a new generation growing up in this era, and they don't know any different.
Do you want to go again?
Just a final question to ask. A recurring comment that you said in your book was why it's so fundamental to understand the freedom of thought and the right to this human right is that once it's lost, we might never be able to get it back. And I think that's a very prevalent point, especially in today's digital context. And my question is, how do we ensure we protect this human right to freedom of thought and do not allow today's digital age become the new norm? Because I think there isn't enough discussion of how dangerous this actually is, and there's more discussion of the excitement. And I think all the more this is an issue with the new generation, because this is their new norm. So they won't ever really understand how it was before. And this invasion of freedom of thought will just be something that is accepted for them.
Well, I suppose writing a book about it, talking about it, ideally getting a documentary about it. I think finding ways to reach out across barriers to talk to people who aren't just specialists in technology or in human rights. So really about reaching out to a wider public.